morning, everybody. This hearing of the Subcommittee of Conservation, Energy, and Forestry, titled Review of the Interpretive Rule regarding the applicability of the Clean Water Act agricultural exemptions, will come to order. I want to welcome everyone this morning. Good morning. Welcome to today's Conservation, Energy, and Forestry Subcommittee hearing. One of the foremost issues facing agriculture today is the newly proposed rules released by the Environmental Protection Agency, the U.S. Army Corps of Engineers, concerning the Clean Water Act's definition of the waters of the United States. Now, we have heard much publicly from the Obama administration about their perceived need for this rule, and there has also been many strong concerns voiced from stakeholders and members of Congress, including myself and several members of the subcommittee. And many experts have suggested that upon closer review, the specifics of the new rule appear to be nothing more than a power grab, meant to expand the jurisdiction of these two agencies into areas the federal government does not currently have a foothold. However, an important related issue that has not been received as much attention is the new interpretive rule, known as the IR, and the Memorandum of Understanding between the EPA, the Army Corps, and the USDA. This document was released concurrently with the waters of the U.S. proposed rule. Now, the interpretive rule, which was enacted immediately, presumes to offer farmers a dredge and fill permit exemption for normal farming, ranching, and silvicultural activities under Section 404 of the Clean Water Act. If and only if those farmers comply with conservation guidelines that until this time have historically been voluntary. Now, this agreement identifies 56 conservation practice standards established by the National Resource Conservation Service and would automatically meet the agriculture exemption for normal farming activities conducted in the waters of the U.S., unless you are receiving government assistance. The Nrcs standards have always been a voluntary guideline for a farmer or rancher in jurisdictional waters. But under this enacted rule, a producer must now meet a federally mandated standard. Failure to do so would create a situation where farmers must obtain permits under the Clean Water Act if the EPA or the Army Corps agree to authorize them, or face stiff penalties. In fact, the enforcement actions under the Clean Water Act could cost upwards of $37,000 per day. Until this point, the NRCS has always had sole authority to design and amend conservation practice guidelines. However, under the new Memorandum of Understanding, the EPA and the Army Corps of Engineers are free at any time to amend the list of conservation practices that would qualify for these limited exemptions. It is beyond my comprehension why these agencies have not chosen to include their list of 56 practices in regulation. Doing so would guarantee regulatory transparency and provide producers input if or when the agencies chose to restrict the list of practices that would qualify for an exemption. The Obama administration has said that the interpretive rule is intended to clarify what normal farming practices can be exempt from dredge and fill permits on a water of the U.S. under the Clean Water Act. The administration has been very adamant to point out that they do not intend for this to be a power grab or expansion of authority, but merely a way to eliminate ambiguity for producers and landowners. However, we hear from farmers and other experts today that this list of practices may be unnecessary. Many producers believe that listing these approved conservation practices provides nothing that the producers don't already have and only invites more federal regulations. And while the Obama administration has created this list of supposed exemptions under the dredge and fill permitting, farmers still have no protection under this proposal from the numerous other mandates of the Clean Water Act, including pesticide application permits under Section 402. Under the Clean Water Act proposal, more farmers and ranchers will be captured under the federal government's jurisdiction. The new exemptions agreed to by the EPA, the Army Corps of Engineers, and USDA have only created a new set of government regulatory standards that farmers and ranchers must now meet. I hope today's testimony may shed light on the reasoning for the administration's interpretive rule and for the Memorandum of Understanding and will allow our witnesses to voice their concerns on this issue. Last week, the administration announced an extension on the comment period for both the waters of the U.S. proposed rule and the interpretive rule. Now, it is my hope that public comment combined with this hearing and other congressional action will persuade the administration to withdraw the current proposed waters of the U.S. and interpretive rules and start from scratch. Now, I thank each of our witnesses for being here today, and I look forward to hearing your testimony. And I now recognize my good friend, the ranking member, for his opening statement.
Well, thank you, Chairman Thompson. I want to thank my friend also for giving us this opportunity to discuss the issue of clean water, the impact on agriculture, conservation, and our rural communities. Thank you also, Chairman, for putting together a very strong panel. I'm appreciative. Undersecretary Bonney, thank you for being here and helping give your input and your perspective on this. And to the witnesses who are here, it's a strong panel representing producers as well as the conservation communities, and for that I am grateful. We are here today to review the Interpretive Rule, NRCS's role in the applicability of Clean Water Act agricultural exemptions. The premise of the Interpretive Rule is conservation practices which benefit water quality and remain consistent with NRCS technical standards should be exempt from Clean Water Act 404A permitting. I think the central question for us in this discussion will be whether or not the Interpretive Rule incentivizes conservation practices and whether those practices actually enhance water quality, while at the same time providing clarity to producers who deserve certainty. We all know that this is a business that there's lots of uncertainties. As we speak now, much of my district is underwater, and in one county alone we've lost 100,000 acres of soybean and corn crops. And so those uncertainties and the impacts of water, lack thereof, too much, and how those producers are able to farm their land is critical. Conservation is this subcommittee's bread and butter, too. Members of this staff work tirelessly throughout the Farm Bill process to craft policies that incentivize conservation, promote sustainable practices, and protect our watersheds. We've proven that we don't have to fall victim to the false dichotomy of conservation over agriculture. We've found solid conservation practices can and do lead to stronger economic conditions. We've discussed the environmental and economic benefits of conservation practices to farmers many times here. Oftentimes, it's the family farmer who's the best conservationist, and have to be, because their most valuable asset's the land. Sportsmen and farmers have had a very close relationship, and we've witnessed this throughout the Farm Bill process. Many farmers are sportsmen, and many sportsmen hunt on private land owned by farmers. Hunting and fishing and general outdoor recreation is a prime example, one of the reasons we invited representatives from the Isaac Walton League here. 47 million Americans hunt and fish. Outdoor recreation is a nearly $700 billion industry and sports well over 1 million jobs. This industry relies on clean water, productive wetlands, but it also relies on a collaborative working relationship with the agricultural sector and private landowners. I don't have to look any further than my own district to see the significance of this relationship. I have farmers in southeast Minnesota who use NRCS technical assistance and leverage EQIP dollars to improve management practice, increase overall productivity on their lands, clean up streams, and open those streams to trout fishermen. Now those very streams are some of the best in the upper Midwest, and sportsmen flock from surrounding states to fish those streams, as well as the producer producing more off the land. Everyone's a winner when we craft good policy which incentivizes conservation practices. Sportsmen and agricultural sector have worked together in the past to achieve significant victories for both conservation and production agriculture. I'm optimistic that in the spirit of pragmatism that both groups demonstrated throughout the Farm Bill debate will continue to guide future policy discussions. I look forward to discussing the issue of the Interpretive Rule, the impact it's going to have on both producers and conservation in a good faith effort to make sure that conservation is incentivized and disagreements are resolved. With that, I yield back, Mr. Chairman.
I thank the gentleman. The chair would request that other members submit their opening statements for the record so that the witnesses may begin their testimony to ensure there's ample time for questions. And I'd like to welcome our first witness to the table, Mr. Robert Bonney. Mr. Secretary, thank you for being here. Mr. Bonney serves as the Undersecretary for Natural Resources and Environment with USDA. Mr. Bonney, please begin when you are ready.
Good morning, Mr. Chairman and Ranking Member Walsh. Appreciate the opportunity to be here today. Thank you for the opportunity to be here today to discuss the Interpretive Rule, which expands the number of agricultural exemptions from permitting under the Clean Water Act. The interpretive rule was released by the Environmental Protection Agency at the same time that the proposed rule on jurisdiction of the Clean Water Act was released for public comment. Today, I'd like to describe the interpretive rule for the subcommittee, USDA's role in helping to shape it, and the anticipated benefits for agriculture, conservation, and the nation's waters. The interpretive rule is EPA's interpretation of the existing exemption for normal farming, ranching, and silvicultural practices under the Clean Water Act related to discharges of dredged and fill material. Under current law, normal farming activities are exempt when they are part of an established farming operation and do not change the reach or use of waters. Normal farming includes things like plowing, cultivating, minor drainage, harvesting, and upland soil and water conservation practices. The interpretive rule does not affect any of those existing agricultural exemptions. Indeed, it adds to them, making even more room for agriculture. This is an important point because there's been some criticism that the interpretive rule might narrow the exemptions for agriculture. It doesn't, and the interpretive rule itself is crystal clear on this point. The rule text says that the rule, quote, does not affect in any manner the scope of agriculture, silviculture, and ranching activities currently exempt from permitting, unquote. With the interpretive rule, now an additional 56 conservation practices, from stream crossings to wetland enhancement, carried out in waters of the U.S. are no longer subject to permitting requirements. Producers can follow the conservation practice standard and implement practices on their own. They don't need to notify the Army Corps or the EPA. They don't need to ask for review or certification of the exempt practice from Nrcs or anyone else. And they don't need to apply for a permit. Producers may want to get technical help from Nrcs if they have questions about a conservation practice, but it's not a requirement. And use of the exemption is entirely voluntary. In addition, the interpretive rule is based on implementation of NRCS's conservation practices, which have proven to be very popular with producers, as evidenced by the strong interest in USDA Farm Bill conservation programs, all of which are tied to implementation of those conservation practices. The interpretive rule is about increasing options and promoting voluntary conservation to benefit agriculture and water quality. Let me tell you a little bit about USDA's role in the development of the interpretive rule. USDA worked closely with EPA and the Army Corps to find new opportunities and flexibility for agriculture that fit with producers' operational objectives and also provide water quality benefits. USDA reviewed its over 160 NRCS conservation practices and evaluated whether, first, those conservation practices might be carried out in waters of the U.S., and second, the conservation practice is designed to enhance and protect water quality. USDA also entered into a memorandum of understanding with EPA and the Army to guide how the agencies will work together to manage the list of exempted conservation practices. At a minimum, the agencies will review the list annually to see how the exemptions are working and if changes are needed. The MOU also clarifies the role and responsibilities of each agency. NRCS's role remains the same as it has been for over 75 years. We work with farmers, ranchers, and other land managers to assist with the voluntary efforts to plan and install conservation practices that meet their needs and objectives. NRCS has sole responsibility for developing, reviewing, and revising its conservation practice standards to guide that work with producers. We're already seeing positive examples, such as in North Carolina, where a stream channel restoration project is now moving forward. There, landowners who are following NRCS practice standards to implement the stream channel restoration project are now able to move forward without notifying the Army Corps or obtaining a permit. As a result, the producers more quickly restore the channel while foregoing the costs of a permit. Further, NRCS staff time is freed up to provide direct technical assistance to other producers. The interpretive rule signals a new opportunity for recognizing the value of producers' conservation efforts. There's no sector of the economy that cares more about water than agriculture. America's farm and ranch families make decisions every day that help to improve and secure our water resources. The interpretive rule will make those decisions and actions a little easier and produce a substantial benefit for farms and ranches, their communities, and the nation as a whole. Mr. Chairman, this concludes my statement. Thank you again for the opportunity to be here today. I'm happy to answer any questions.
Well, thank you, Mr. Bonney. The Chair would like to remind members that they will be recognized for questioning in the order of seniority. For members who are present at the start of the hearing, after that, members will be recognized in order of their arrival, and I appreciate the members' understanding. And so I now take the liberty of recognizing myself for 5 minutes of questioning. Once again, Ms. Bonney, thank you for being here today. There's quite a bit of concern and uncertainty among the industry with this issue, and we're hoping to achieve some level of clarity today. The EPA has issued the interpretive rule to clarify that a long list of conservation practices are exempt from dredge and fill permit requirements under the Clean Water Act Section 404 exemption for normal farming and ranching activities, so long as the practices comply with NRCS's standards. So as I understand it, a farmer only qualifies for any one of these exemptions if the farmer follows NRCS's standards. Is that correct?
That's correct.
Okay. Now, how does that compare to the current law?
So under current law, there's no presumption that not following those standards is somehow a violation of the Clean Water Act. What we've tried to do is provide clarity that these 56 practices are exempt so that landowners have certainty that they can move forward with those under the Clean Water Act without having to seek a permit. So
currently, so must a farmer currently meeting NRCS standards to qualify for normal activities that are exempt under Section 404? Do they have to meet those standards in order to qualify for
this particular, under the interpretive rule, for this particular, for the interpretive rule, yes, they have to meet those standards. And
so we've actually, so just to be clear then, we've gone from voluntary to compulsory.
The interpretive rule is entirely voluntary. It doesn't require any landowner to undertake any of these activities. If they want to undertake these activities, we've given them an exemption, clarity that there's an exemption for doing that.
So if we want them to experience a world of hurt, then they will comply.
Well, I'm not sure I'd say that our conservation practices are a world of hurt.
Yes.
Excuse me?
Well, if they don't want to be facing the consequences of the Clean Water Act and all of its, up to $37,000 fines a day, the presence on the farm, the interruption of farming activities, interruption of providing, affordable, high quality and safe food for the nation. If they don't want to, they're really, it's compulsory to, what was voluntary is now mandatory.
I guess I disagree with all due respects with the characterization. I think what we've done is provide a menu of activities that they can undertake and have clarity that they won't be in violation of the Act.
And I think that's going to be the topic of today's discussion, so we'll get into more. Let me have a little bit of time. Yeah, is it true that any or all of these exemptions can be changed, curtailed, or even eliminated by NRCS without written notice to the public or without public input?
So our plan, and the MOU lays this out, is to review these exemptions annually with EPA and the Corps. We take this MOU very seriously. We didn't enter into it lightly, and we're going to do the best we can to not only maintain the 56 exemptions that are in there, but look for opportunities to add to it.
So what you're telling me is you're going to take the complexities of three major players, your agency, the Army Corps of Engineers, the Environmental Protection Agency, and they're going to subject to changing this thing on at least an annual basis. Can you tell the committee or submit for the record the process by which the NRCS establishes these standards, what input farmers have in their development, and what happens if farmers disagree with NRCS?
So we've, over the last several years, have heard a lot of input from agriculture on this issue. And one of the things we've heard is about the importance of certainty and looking for ways to expand exemptions. As we met with EPA and the Corps to discuss the Clean Water Act, that was one of our primary concerns. And in working with those two agencies, we looked at practices that we thought both are practices that could be done in waters of the U.S. and that provided water quality benefits.
Yeah, well, I find myself in an unusual situation because I'm a fan of NRCS. I was just with a large group of your employees yesterday talking to them, but I find today that in this situation, and I think you're sincere when you say that you take in the farmers' interest because you put boots on the ground, but with this interpretive rule, there was no public comment period, to the best of my knowledge, and yet there wasn't even notice. It went into effect immediately upon its publishing, and so somehow we've veered away from the Nrcs that I'm accustomed to. So, and my time has expired. We're going to try to stay within the limit so we can give everybody lots of time for questions. And I'm pleased to yield to my good friend, the ranking member. Or I'm sorry, we're going to yield to the ranking member of the committee, Mr. Peterson from Minnesota.
Well, thank you, Mr. Chairman. I appreciate it. Appreciate you holding this hearing. And Mr. Bonney, it's been told to me that nothing is going to change here, and that we're going to include all of the practices that are currently being done. Why? It apparently, under this deal, the Practice 554, water drainage management, is not listed as a practice. It's something that currently is being done. Why was that left off?
Well, I think we, as I responded earlier, we looked at two criteria for these, whether they were water quality benefits and as well if they're done in waters of the U.S. We tried to choose practices that did that. Our hope is that we may be able to provide additional practices going forward.
But that's going backwards from what we're doing now. So, I mean, how do you say that you're covering everything? It's not true.
I wouldn't.
My experience out there since this has come out is the Corps of Engineers has gone off the reservation, and there was one meeting where they stood up and said, we're going to go from navigable waters to all waters in the prairie pothole region because we're going to restore all the wetlands. One of their people said that. Well, that's we have the NRCS got a deal with the Corps that they're going to follow the NRCS determination. I got another situation where a guy wants to buy a dairy farm or build a dairy farm, and NRCS is willing to permit it and got a mitigation situation which he wants to comply with, and the Corps is standing in the way. So I don't get this that you say that nothing is going to change. In my experience of what's going on out there, that's not the case at all. And are things like dikes and levees on WRP and wetland easement programs, are they subject to 404 permits? How about tiling? I mean, is that, so what you're saying is they're going to still be subject to 404?
Not in the...
So now we're not doing that?
Not in the interpretive rule, but in the proposed rule, there's now an exemption for tile drainage related to groundwater.
There is?
Yes.
So
it's new.
What's the difference between the interpretive rule and the...
So the interpretive rule interprets normal farming and ranching and provides clarity that these 56 practices don't require a permit under Section 404.
Why were these others left off then? Why were they left off there and put in this other place?
Well, as I mentioned earlier, we followed two criteria for which exemptions made the list. And with respect to the Corps, as it affects the interpretive rule, we're committed to having conversations and have already started that process with both EPA and the Corps to ensure that they understand that there's consistency across the country in how we look at the interpretive rule.
Well, I wouldn't hold my breath because the Corps in Omaha has a whole different perspective than the Corps in St. Paul. And that's something I run into all the time as well. What about the dirt piles that are left after you tile? When you tile, you got a little bit of dirt on the top of the ground. Apparently, they're saying that that's requiring a permit, a 404 permit.
So I don't know the answer to that question. Probably a more suitable question for EPA or the Corps. We were, in our conversations around the proposed rule itself, again, our emphasis is looking for ways that we could expand some of the exemptions for agriculture.
Well, it seems to me you've left some of these things off, and we need to. The other thing that concerns me is we had a letter in one situation where out there the Corps is telling people that they can't get to this for 8 to 12 months. And so they're going out there trying to grab more jurisdiction, and they can't even do the work they got now. And that somehow or another, I'm going to go explain to people that this is better. I mean, that dog doesn't hunt, and I just don't see where we're getting with this.
Well, the commitment I make to you, sir, is that we're going to do our best to make sure there's consistency as it relates to the interpretive rule with how the three agencies view it. NRCS is in charge of its own standards. As I noted, no landowner has to go get certification or otherwise check in with any of the three agencies.
Are you going to guarantee me that we're not going to go backwards from all the progress we made in Minnesota with NRCS working with these other agencies, that what's going on here is not going to move us backwards?
I'm going to commit to you that we're going to do level best to make sure that's the case.
That's what it seems like is going on now, and that would be a bad outcome. Thank you. I yield back.
Thank the gentleman. Yields back. And now recognize the gentleman from Ohio, Mr. Gibbs, for 5 minutes.
Thank you, Mr. Chairman. Thank you for holding this important hearing. And last week in my subcommittee, Water Resources of Transportation Infrastructure, we had the Deputy Administrator of the EPA, Robert Perskespi, and Joellen Darcy, the Assistant Secretary for Army Corps, and several other stakeholders in the panel. And after several rounds of questions in 2 panels, it's safe we didn't get our questions answered, and it's troubling for farmers and ranchers and anyone, home builders, everybody. There's a lot of uncertainty out there. Also, on the proposed rule, it's clear that no state EPA has come out in support of it. But the interpretive rule we're discussing today is effective in March is concerning. And I'm concerned about how this interpretive rule may discourage producers from participating in conservation practices due to the mandatory and expensive permitting process and lack of clarity. And I want to follow up on the Chairman's question a little bit, and as you stated, Mr. Bonney, if you are doing a conservation practice, one of these 56, and you're in compliance and working with NRCS, you are exempt. I'm looking through the list here. Is it safe to say that if a producer goes out and is doing a practice like I see here, structure of a water control or building or simple practice is building fence, and is not working with NRCS, or maybe is just doing it on himself, he would not be exempt? Is that true then?
No. They do not have to work with NRCS as long as they follow the practice standard. They are exempt. So there's no required certification from NRCS or any other agency.
Who's the enforcement mechanism that is?
There's no requirement that any landowner check with any federal agency. All they have to do is follow the standard.
Well, my concern is with the proposed underlying rule, the expansion of waters in the United States, EPA could come in and you could say exempt, and they could challenge if that farmer is not in compliance with NRCS. So it's going to be,
doesn't change any of the anything as it relates to the proposed rule, but what we would argue is that we've provided additional certainty for these 56 practices, and landowners will be better off because of that.
Well, I think I have to the Ranking Member Peterson's questions there. That would be I guess time will tell, but a very concerning issue. Also, those exemptions, even if you are compliant with NCRS, only exempt you from 404 permitting. I have a bill, H.R. 935, about Regulatory Burdens Act, about NPDES permitting under 402. My question in there is, is farmers exempt doing like a structure or water control on this 56 list, exempt under 404? If they expand the waters of the United States, wouldn't they be liable under 402 for permitting and also be liable for possible lawsuits?
So this doesn't change anything related to 402. As you point out, it's only for 404. The existing exemptions for stormwater runoff or irrigation return flow still apply for 402.
Especially if with the expansion of waters in the United States, because currently under the Clean Water Act when it was passed, agriculture had a blanket exemption from the 402, 404 permits. But under the rule, if they expand their jurisdiction, which is obviously, I think you'll hear in the next panel that they are. We heard that last week in my committee. Then they would be opened up to more regulatory burden. And possible citizens' lawsuits. Would you agree?
Potentially, yes.
So that's a real concern. Also, in the rule, in the underlying rule, there's a lot of ambiguity and vagueness, and it seems to me that things are really stacked on the regulatory side. It gives them the flexibility, and because what I would document as proof is they stated in my committee that they would look at things a case-by-case basis, and gives them the flexibility if they want to enforce this or not enforce this. And I can see the attempt by USDA here to say we're doing these 56 exemptions, but I think that there's enough ambiguity and vagueness in the underlying rule that these exemptions don't maybe go to the root of what you're trying to do. So I really have concerns to that, and I think that's an issue that, and I would concur with the chairman that this rule just ought to be laid on the table, the underlying rule, the proposed rule, and the interpretive rule, because I don't think it's helpful. I think we can move forward to having less conservation activities on farms because of fear of doing anything opens up the door to litigation and permitting and delays in getting those permits if they are required to get those permits. So I yield back my time.
Thank the gentleman. Now recognize the ranking member for 5 minutes.
I'd yield a portion of my time to the full ranking member.
Thank the gentleman. I have a list here of the conservation practices from Nrcs, and over half of them are not listed. The ones circled in red are listed, the others aren't. So I'd like to submit this to Mr. Bonney and have him explain to us why these ones that aren't included, why they weren't included. It's over half the list, so without objection.
Without objection.
Great. Well, thank the ranking member. Thank you, Mr. Bonney. Well, I think what you're hearing is, and again, you've got good actors trying to get this right. I can tell you that what's being conveyed by my colleagues is what I'm hearing also, that there's great uncertainty. And these are by folks that have lived a lifetime of trying to incorporate conservation practices to the best of their ability while still trying to produce on the land. So I think you're hearing this. I hope you're hearing from folks that want to get this right, but there's little doubt there's confusion. And we need to get the heart of why that is. One of the questions, and it kind of got hit on, and I'm certainly in full disclosure, I'm biased Article 1 of the Constitution, that it's our job to do it. I'm always curious when an agency goes out and sets a rule, how much input did the stakeholders have? Because I'm hearing from some of my folks that they felt pretty blindsided by this. They felt like there wasn't collaborative. Could you kind of explain a little bit to me of what type of outreach was done to get out to those stakeholders?
So, I think, as you know, the administration, this is a rule, waters the U.S. There's been earlier draft guidance that's put out. There's been ongoing conversations with USDA and agriculture around this issue broadly as it applies to waters of the U.S. over the last 5 years. We've had a number of conversations with folks in agriculture about their concerns, and one of the concerns we continued to hear was the need for certainty, the need to broaden exemptions. We viewed the interpretive rule as a way to be responsive to those concerns. We've got a public comment period right now on the interpretive rule that will close in July. But that's not going to be the end. We hope we will have an ongoing conversation with agriculture on this to improve its implementation. If there are opportunities to add additional practices, we want to hear that as well. So the other thing we'll do is as much outreach as we can both to agencies and agriculturists to inform them about how the interpretive rules to work.
Did you anticipate there'd be this type of, concern and level of concern? Does it surprise you when you hear this, or were you prepared for that?
Well, on the one hand, I would say it's obviously clear that this issue, waters of the U.S. broadly, has always been of deep concern to agriculture and forestry as well. We understand that. We understand that doing things around this can be controversial. We do think that what we've done here is increase the number of exemptions through a voluntary basis using conservation practices that are very popular with landowners, so that we hope that this will be something that will be accepted as the opportunity that we think it is.
I do worry that the gentleman from Ohio brought up a great point, that we have to be very careful in doing this so we don't disincentivize. We don't get people that want to do this right, because our goal is to get this conservation right. The goal is to, and I want to be clear, regulations that are smart, that clean our waters, that allow for other industries to thrive aren't burdensome. Those are smart. But if they do get to that point of being burdensome, or they become a lack of clarity, or they become it's easier not to do it, I think that is a concern that you got. And I hear this from folks that I can absolutely tell you, Mr. Undersecretary, are committed to getting this right, feel that confusion. When I hear this, just as an example, now how do I go out, and you've heard this from someone, just something as simple as this. Someone wants to do fencing. What happens there? What changes for them if they were doing fencing 2 years ago and they want to do fencing under this interpretive rule? What's different, and why would someone and these folks be confused about this?
Well, the fencing standard by Nrcs is pretty short and it's very broad. If a landowner basically builds a fence that's in keeping with that, and I would submit to you that standard, I would submit to you that's going to be a fairly standard, easy standard to meet. They're going to have a clear exemption under the Act. They can either do that themselves by getting the standards off the website, for example. They can reach out to Nrcs if they want to do that. Nrcs may be willing to cost share that action. They can reach out to a technical service provider or others. Purely voluntary. Don't have to reach out to the federal government if they don't want to. Any of the agencies. It's just an option that they can, a voluntary option that they can take if they want.
So your interpretation, your understanding, and you're telling me for clarity on this, nothing changed for those people. They're not open for any more lawsuits. They're not open for any.
All we've done is provided an additional option for someone that wants to seek some clarity and clarity about an exemption under the Act.
Okay. With that, I yield back, Mr. Chairman.
Thank you, gentlemen. Now I recognize the gentleman from Arkansas for 5 minutes.
Thank the chairman. I'm a little concerned about the 56 practices too, and so I would also associate myself with the ranking member as well. Also, the other thing that the chairman mentioned is the relationship the Nrcs has had up to this point with farmers. I think it's been certainly consistent in my district as well that the NRCC has been looked at as a source of technical expertise with respect to things like surface water retention and things of this nature. But as my friend from Ohio pointed out in our subcommittee hearing last week, it seems like the NRCS has been sort of caught up in this issue with EPA and the Corps of Engineers to become now somewhat of a regulatory body. I never got an answer last week, so I'll try it with you. One of the interpretations in the Clean Water Act from the Supreme Court is significant nexus. So when we talk about a 402 permit as an example, and somebody has some drift, and that waterway then is in contact with a regulated waterway, does that constitute significant nexus, and who makes that interpretation?
So I'll do the best I can. Probably a better question for EPA or the Corps. I believe spray drift is not regulated. I believe that if you apply a pesticide directly to a water, that can be subject to regulation. And I believe, if you follow the recommendations of the specific pesticide, that you're in compliance with 402.
My other concern, among others, I've got 5 minutes. I could never enumerate the concerns I have about this. But I'll do my best in the time that I'm given. As an example, so we talk about spray drift, some of these things that happen. What about a cattleman? If you've ever been around cattle, they're going to eliminate where they please. So your cow walks into a stock pond that may be draining into a ditch that flows into a regulated waterway and eliminates. Who's going to address that issue?
Again,
and that cattleman now subject to lawsuit?
Again, probably a better issue for EPA or the Corps, but I would say it's very much strikes me as a normal farming and ranching activity. I would say that in the interpretive rule, we've added a practice for livestock crossing if there are concerns there.
And then this was alluded to, fence building, obviously, and I go back to my comments about the technical resources available that are provided by NRCS, which up to this point have been, and particularly in my district, there have been some great projects as a result of interaction and collaboration with NRCS, and we'd like to keep it that way. Is the NRCS now going to, their core competency up to this point has never been fence building, but it sounds like now there's going to be a standard set prescribed by the Nrcs as an option, and we hear that repeatedly used an option, but it doesn't sound like we're giving our producers really any options to avoid being caught up in regulatory regime here.
So we've long had a standard for fences. I have it here. I'd happy to provide it to your staff. It's someone that's grown up on a horse and cow farm. I've been around a lot of fences. I think most producers would meet this standard fairly easily. And with respect to NRCS becoming a regulatory agency, again, there's no requirement that any landowner seek NRCS's certification for any of these practices.
Okay, let me ask you this, and again, I didn't get this answer from the EPA or the Corps. Who actually makes the determination on significant nexus? Is this something that the three of you agencies are going to get together and say, yeah, that's a significant nexus and we're going to go forward and regulate?
USDA is not involved in regulation of that aspect of the Clean Water Act or any aspect of the Clean Water Act.
Okay. And the other issue I have is if a farmer is not following an NRCS standard, is that by interpretation, does that mean they're in violation of the Clean Water Act? Are they subject to a $37,500 fine?
Absolutely not. There's no presumption that not following NRCS practices somehow violates the Clean Water Act.
Well, I appreciate your testimony today, and again, I share the concerns that the chairman has. I think our producers have enjoyed a very productive relationship with the NRCS up to this point, and my concern is that what has happened now in regards to the Clean Water Act it could compromise that relationship and foment distrust among producers with respect to the NRCS. And with that, I yield back.
I thank the gentleman for yielding back. I just want to point out in terms of the exchange on the pesticide spraying. Just a little clarification, kind of contrast what you said. EPA currently regulates pesticide spraying, and they have, best of my knowledge, 2 additional restrictions pending that they're considering. So.
That's right, and I didn't mean to suggest otherwise if I did.
Okay. Now pleased to recognize the gentleman from North Carolina, Mr. McIntyre, for 5 minutes.
Thank you. Thank you very much, and thank you for being here today. I have 2 or 3 questions I'd like to get in, so I'll just go right through them. First of all, in North Carolina, several state agencies have standards for many of these activities that differ from the NRCS standards. Will these activities be exempt from Section 404 permits only if they adhere to the NRSC standards?
Yes.
It's even though they otherwise meet all the necessary state regulations?
Yes.
Okay, so this is adding a layer of additional standards now that they're going to have to meet.
Entirely voluntary.
Then if they're, I guess that raises the question. You did say earlier, and if you just repeated, they're entirely voluntary. You said earlier no landowner has to get certification. You said earlier this is just meant to provide additional certainty. Yet now you're saying even though they're already meeting the requirements of the state, and even though they may already have done everything necessary for this Section 404, they have to meet these NRCS standards?
No, if they're meeting the requirements of Section 404, then they're fine. The interpretive rule doesn't do anything to change the exemptions already existing.
All right. Well, I guess we have an old saying in the South that if it ain't broke, don't fix it. And if it is entirely voluntary, as you've just said, and no landowner is required to get certification, several of our stakeholders, some of whom are in the audience and that we'll be hearing from in the second panel, have asked to withdraw the interpretive rule. What would be the consequences then of withdrawing it if it's entirely voluntary?
Well, in my opening testimony, I talked about a landowner in North Carolina who's utilized this and foregone both the expense and the delay in a permit. We think we can save both time and money through this exemption like we have in that example I used in North Carolina. We think we're providing additional options, voluntary options for producers if they want to use it, and we think over the long term that will be of great value to agriculture.
Okay. Well, and I respect the fact that that's an opinion because you've said 3 times there that we think. Obviously, there are other thoughts that are occurring, and we appreciate you coming to answer our questions. So I would hope that you would think about withdrawing the interpretive rule, because if it's not adding anything of additional quality, and if the requirements can legally otherwise be met, then this is indeed adding another layer that has to be considered. For instance, the interpretive rule and the regulations that cover the existing Clean Water Act exemptions for agriculture say that an activity must be part of an established or ongoing interpretation to qualify as not needing a dredge and fill permit. What is meant by established or ongoing? And some have suggested activities on a farm that took place in 1977 are not established, but those that took place after 1977 are ongoing. Is that correct? And is 1977 a magic date, or is there some other specified date?
I'm not aware of the issue related to the year 1977. I think the established and ongoing applies to the normal farming and ranching exemption. I think the most important thing, as I understand it, again, probably a better question for EPA and the Corps, the most important thing is that there not be a change in the use of a water of the U.S. And I think that's the most important piece about this exemption.
Okay. It was in 1977 that Congress amended the Clean Water Act by exempting routine farming, silviculture, and ranching activities, 33 U.S. Code 1344. So that's where that date comes from, and that would be, again, a practical application question of this. So as we consider these concerns, the listing of these additional practices, and if they are indeed supposed to provide additional certainty, it sounds clearly from the questions being asked and the concerns being raised today that actual is providing additional uncertainty. And I would encourage, if that is truly the intent of the rule, which you have said it is to provide additional certainty, then it needs to be revisited before it's implemented. And so we appreciate your coming before us today to hear our concerns. We appreciate the hearing. That's the reason for the public input. And if July sounds like it's too soon of a time to implement this, we would ask it be tabled until there can be more certainty. And with that, I yield back. Thank you, Mr. Chairman.
Thank the gentleman from North Carolina. And now recognize the gentleman from Michigan, Mr. Benishek, for 5 minutes.
Thank you, Mr. Chairman. Mr. Bonney, I'm curious as to who you consulted with before, putting out this interpretive rule, because we've got a lot of people here that say they weren't consulted. So you said you consulted with people in agriculture. Who exactly was that?
Well, let me be clear about what I meant by that. I didn't mean to suggest that we consulted with folks on the specifics related to the interpretive rule, but we've had ongoing conversations with agriculture for a long time about the Clean Water Act, how it applies to agriculture, and we've had ongoing conversations with folks in agriculture about the need for broadening.
Who are those people that you consulted with?
We
name them.
We hear regularly from livestock groups, from other groups that have concerns about the need for further clarity and exemptions in the Clean Water Act.
Was any groups here in the audience been consulted about this?
Well, again,
raise your hand.
Don Parrish and I have had lots of conversations about the Clean Water Act. He would say, and as would I, that we had never had a conversation about the specifics of the interpretive rule.
Well, I guess I have another question then too. The difference between a legislative rule and an interpretive rule. And as my understanding is that an interpretive rule sort of defines the rule of law, but the legislative rule actually makes the law. It seems to me that this interpretive rule actually is a legislative rule, and that would require a comment period because it actually defines, 56 things that weren't previously defined as the law, but now it is. So how is this not this what you call an interpretive rule? How is this not a legislative rule which would require a comment period?
So we do have a comment period that's open into July. What the interpretive rule does, it interprets what normal farming and ranching activities are and defines that as including conservation practices, in particular the 56 conservation practices that we've laid out.
I guess this is just not my understanding of what the difference is, because my understanding is that the interpretive actually interprets what the law says, and then your rule seems to define it, which is the definition of a legislative rule. And I don't understand why the comment period wouldn't take place before you do the rule rather than after you do the rule. What's the reason for that?
We wanted to include conservation in normal farming and ranching activities. We want to expand the number of exemptions. As I say, our hope is that we have reflected what we've heard from agriculture and can continue to do that as this goes forward, and we hear both concerns and praise about how this thing rolls out.
But as I understand it, this comment period is about the underlying rule, not the interpretive.
There are two comment periods. The comment period for the proposed Clean Water Act is open until October. We have a comment period for the interpretive rule open until July 7th.
Why is it that we have to going to be changing this rule every year?
Well, our hope is that with conversations with EPA and the Corps, that there may be opportunities to add additional practices, look at this interpretive rule as it's played out.
Isn't that really hard on people that actually have to comply with these rules, that they're subject to having it changed every single year?
Well, what I would say is I think this, again, is entirely voluntary. We think we've provided additional options for conservation and for landowners to undertake conservation activities. So we hope that this will be seen as an opportunity for agriculture.
I'll yield back the remainder of my time. Absolutely.
I just want to say, Secretary Bonney, I'm starting to lose track of how many times on agriculture questions you're deferring to the Army Corps of Engineers and the EPA, and which is a big part of my concern. I trust the USDA when it comes to agricultural practices. So at this point, I yield back, and the gentleman yields back. My pleasure to introduce the young lady from New Hampshire, Ms. Custer, for 5 minutes.
Thank you very much, Mr. Chair, and thank you, Mr. Bonney, for appearing before us today. I think we join, this is a bipartisan in our concerns that have been expressed certainly from agricultural producers in New Hampshire and many states across the country. I agree with the opening comments that the farmers in my district do care a great deal about the environment and about the land, and including mitigating runoff from streams and wetlands and ensuring that their animals have access to clean water, et cetera. But I think the concerns that you're hearing relate to the level of engagement in the process by the agriculture community. And I share the concerns that have been expressed here on both sides of the aisle that the stakeholders in my district did not feel included in this process. With that being said, I guess the question at this point is, what are the plans that NRCS has moving forward on outreach and education? Because I think it may come as a surprise to some people that these are voluntary, given the context of the rulemaking that's going forward at the EPA, which nobody interprets that to be voluntary. I mean, there's a great deal of concern. And I think already, this is nothing new to you, but we're venturing into a volatile area when the topic is navigable waters, and you end up talking about ditches and not even streams. I mean, in our region, these are seasonal. There's nothing navigable about these waters. And so I just would ask if you could spend some time on how the Department of Agriculture or the NRCS can move forward to educate farmers who are trying to do the right thing. But in my district, these are small farms. These are not big corporate farms. They don't have lawyers. They don't have the ability. They don't, frankly, even have the time to contend with a whole new set of rules.
So with respect to the interpretive rule, we're trying to do the best job we can at educating our own staff that interact with a lot of your producers and others with respect to the interpretive rule. So we'll do the best job we can there. We're also having conversations with EPA and Army Corps so they understand this as well. We've done other pieces of outreach. For example, we've put a Q&A up on our website that explains what the interpretive rule is and what it isn't. We're going to continue to do those efforts and, again, emphasize that this is entirely voluntary, that it provides options for landowners if they want to use them, and we think can be helpful to them in putting conservation practices into place on their land. Might
I suggest that we have a built-in process, and I'm a new member of Congress and new to the Agriculture Committee, but one of the things that I've been so impressed by is the network of organizations and people all across this country who are very, very involved in, they rely on these organizations to keep them abreast. As I say, they don't have time themselves. Is there any plan for outreach to these organizations, many of them that are represented in this room? And if not, could you incorporate that into your planning? I think one of the things about government regulation generally, and in this particular case, you're familiar with the concept of the interpretive rule. I think it's pretty clear that others are not. And frankly, I'm an attorney. The idea that this was intended to provide clarity, I can't see that that's been effective. Could you consider reaching out to these organizations to help engage the dialogue, engage the farmers and the producers in the dialogue? I think you'd have a much better outcome and, frankly, a much better understanding. They would have a better understanding of what your intentions are.
Absolutely. We'll continue to do that.
Thank you. I'll yield back. Thank you.
I thank the gentlelady. Now I recognize the gentleman from Colorado, Mr. Tipton, for 5 minutes.
Thank you, Mr. Chairman. Mr. Bonney, thank you for being here. I'd like to follow up a little bit on some of Mr. Benichek's questions that come to you. You referenced Don Parrish, who I assume is in the office, in the building here today. Has it been your experience that the ag community is coming in and saying, regulate us more?
Of course not.
Of course not. So when we're talking about actually hearing, this is a classic example of the cart before the horse. Putting out an interpretive rule to begin with, and then we're going to gather comment afterward. Explain to me, help me understand the sense of that.
So I think, as I said before, we've heard through the last several years a lot of comments of concerns of the Clean Water Act itself, the need for additional exemptions. In response to that, we believe the interpretive rule response.
Additional exemptions. So what people are saying is we're regulated too much.
Well,
is that what you're hearing?
We are hearing a lot of concerns about the Clean Water Act from agricultural producers, absolutely. And our response to that was to put together with EPA and the Corps an interpretive rule that we think will provide some options there for increased exemptions.
And can you understand how disconcerting this has to be to our farm and ranch community and other segments of our economy when we're saying, hey, that's probably a better question for the EPA or for the Corps?
Well, when it comes to the proposed rule itself, I don't want to speak on behalf of the Corps of the EPA. Provide some insight there, but I think my job today is to talk to you all about the interpretive rule and how it can address some of the concerns of agriculture.
But when that's put together collectively, effectively what we're doing and what we are seeing is not creating certainty, but more confusion, more frustration, effectively coming out of the federal government that says, hey, we're here to help. And, and the shiver runs up the spine of every independent producer that's out there.
Well, I'd say I think Nrcs has a strong record of working with our producers, has developed a lot of trust over the years. We think this will provide additional options if producers want to seek out Nrcs. As I said before, they don't have to.
Right.
And so we hope this adds to the tools that producers have to comply with the Clean Water Act.
Can you give me a little bit of clarity? Because as you were going through your testimony, you were saying that it applies to established farming areas. What if there's an adjacent field that hasn't been farmed? Farmer, rancher buys that. Does it then apply? Different rules apply to that new land that they purchased?
If it's not in waters of the U.S., they're free to farm and ranch.
Well, I've got to tell you, I don't know what's not going to be applicable to the waters of the U.S. This is the biggest water grab in American history coming out of the EPA. Trying to be able to control water and the impacts that that's going to be. Mr. Bonney, the USDA has stated that the interpretive rule only applies to adjacent and neighboring waters, and it's also been said when the USDA is able to show a hydrologic underground connection, however tenuous, you will regulate those waters, even though they fall outside your stated application of the rule. Can you explain to me how those two statements don't conflict?
I don't understand the question.
When you're saying you aren't going to regulate it, there are going to be applicable rules. We just had a directive coming out of the Forest Service. It's certainly going to be applicable to the farm and ranch community in terms of underground water, but you aren't going to be regulating it. How is this not a conflict?
So groundwater in the proposed Clean Water Act rule is not regulated. I think it's an exemption that's fairly
You need
clear.
to get a hold of the Forest Service. They're just putting out a directive.
Forest Service has put out a directive that is that will clarify and provide some consistency across the way we address groundwater as part of resource management plans, projects, and other things. And the purpose of that directive is to provide greater consistency across the Forest Service. It doesn't provide any new authorities to regulate groundwater, purely, I think, about consistency.
You know, actually, if you read through that, my interpretation of it, and apparently we've all got the freedom to be able to look at this, is farmer, rancher could divert legally out of a stream to be able to fill a stock pond, to be able to irrigate a field. They're going to be in violation.
So stock ponds are specifically exempt under the Clean Water Act?
Not if you're looking at that groundwater rule that's going to be actually. This, again, I think it actually just points to the government coming in. We've added 174,000 plus pages of regulations. 4,000 new regs are coming down the pipeline right now. And when you're talking about an annual review coming up, what kind of certainty is that going to give? I think several members have spoken to that.
Yeah, the purpose of the annual review is to look at the practices, see if there are additional ones that we can add to this, and to see how the interpretive rule is being carried out.
My time's expired. Thank you, Mr. Chairman. Thank you, Mr. Roney.
Thank the gentleman. Time's expired. Now recognize the gentlelady from California for 5 minutes.
Thank you, Mr. Chair. I have no questions.
Gentlelady yields back. Now recognize the gentlelady from South Dakota, Ms. Nome, for 5 minutes.
Thank you, Mr. Chairman. And Mr. Undersecretary, in South Dakota, we've had ongoing problems with Nrcs, with inconsistent policy from county to county, a backlog of problems, some producers waiting months, if not years, for determinations. So it hasn't always been a good experience. Some counties are very good, some are not. And these determinations impact how a producer is able to participate in programs. And you say you want producers to participate in programs because it is better for our water quality and conservation practices. But Nrcs is making it very difficult for producers to participate. And now that while they're working to address this backlog of determinations, what issues surrounding wetland determinations need to be resolved to provide producers with certainty so that they can farm without being worried about being out of compliance?
So, yeah, we do have a backlog in wetland determinations, not only in your state, but in the upper Great Plains. We've reduced the backlog. We've put additional resources. We announced earlier this year even additional resources on top of what we've already put there to reduce the backlog. We're also working to improve consistency across the wetland determinations, because you point out there has been some inconsistency.
Well, so I have a question. If the Army Corps of Engineers comes to you and asks if a private landowner's practice is in compliance or out of compliance with NRCS standards, or someone calls the NRCS and tells them someone's not following the standards, will NRCS have to look into it?
We have no regulatory requirements, responsibilities under the Clean Water Act.
You have absolutely no requirement if somebody comes to you and says a producer's out of determination, including the Army Corps of Engineers, to look into it or to... No,
and as I understand, there are, in the Farm Bill, there are requirements that we respect landowners' privacy in terms of what they're doing on the ground. So,
who would look into that situation?
Well, there's interpretive rule doesn't change anything about the.
So you're not quite sure if somebody's concerned or the Army Corps of Engineers wants determination. You won't provide it, and you don't know who will. No, we provide compliance determinations related to wetlands, yes, but that relates to our USDA programs, not to the Clean Water Act. Which adds to the backlog and the workload that you have to deal with within NRCS.
We do have a backlog, and as I said, we're working to reduce it.
Well, under this proposed interpretive rule, some activities are exempt if they follow NRCS standards. So do the standards ever change?
Every 5 years, we review standards and on a rolling basis for all our conservation practices.
So it looks to me that in 2015, do you know how many of those exemptions are up for review?
I don't.
Looks like about 30 of them, to me, are up for review. And potentially, we could see farmers who are in compliance today But in 2015, if NRCS decides to update them, they could be out of compliance. Is that correct?
I don't believe that'll be the case because these conservation practices, the Clean Water Act, the exemption is from dredge and fill. So the concern is when the practices are being put in place. So I believe the practices being put in place, I don't think there'll be a problem here.
So they're grandfathered if they've done the practice prior to 2015. It's when somebody does a new project in 2015 and forward is when the new standard is going to apply.
Yes.
Okay. And the producers will be notified of those changes, and that will, therefore, because we have 30 of these 56 exemptions going forward, you believe that will provide them with more certainty?
We hope it will.
Okay. Well, if this rule provides that kind of certainty for the agriculture industry, I'm baffled because none of the agriculture industry wants this. Nobody is in favor of it. So that's what I'm struggling with today is that you're here and you're telling us this is necessary, that it's needed for certainty, for confidence of these practices, yet nobody in agriculture wants this. How do you reconcile that?
As I said before, we've tried to be responsive to the concerns related to the broader Clean Water Act as part of this. We think we've provided additional certainty as it relates to these 56 practices. Our expectation over time is that producers will see that as they utilize this, and that they'll see this as an opportunity. Again, it's entirely voluntary.
And you've been saying that over and over, but what the thing is that if we want people to participate in conservation programs and we want them to do activities on their land that improves our water quality, then we want to make it easy for them to participate. And we want to make it so that they want to be involved and they can see the improvements on their land, and we don't want them to have to worry about falling out of compliance all the time. And that's the thing that is making this so difficult to reconcile, is obviously the agriculture industry has weighed in here and said this makes it much more difficult. They're very concerned about it, and yet we have no comment period, and the Nrcs is steamrolling ahead. And I firmly believe that this activity should be rethought by your agency, your department, and get into consultation with the agriculture industry. With that, I'll yield back, Mr. Chairman.
Gentlelady yields back. Just one point of clarification on a question that the gentlelady had asked. The grandfathering of until 2015. Is that grandfathering till 2015? Before 2015? Is that in the EPA and the Army Corps of Engineers proposed plan?
No, I'm not suggesting. The point I was trying to make is I think most of these practices, the exemption against dredge and fill is against dredge and fill. And so a lot of the concern is when you put the practice in place. So my suggestion is that I think when these practices are put in place, that's when the exemption is most pertinent to the producer. So I'm not sure that the fact that the practices will change over time will have a significant impact on producers.
So this grandfathering may be okay with NRCS, but we actually don't know whether the grandfathering is recognized under the proposed role that EPA and Corps of Engineers has.
Well, again, I don't want to introduce. I'm not suggesting that there's grandfathering. What I'm suggesting is the way this plays out on the landscape. I don't think this will be a substantial problem.
I do too. Please recognize the gentleman from Minnesota, Mr. Nolan, for 5 minutes.
There we go. I want to thank Chairman Thompson, Ranking Member Walz for conducting this hearing, and Mr. Bonney, thank you for being here. I'm not going to take much time. I do want to associate myself with the remarks of my colleagues here with regard to the need for clarity, and we appreciate the fact that you're at least attempting to do that. But, the concerns that have been expressed here for agricultural producers, with regard to the Army Corps and their inability to review permits in a timely manner. That's a serious matter. The uncertainty that exists out there, the need for more outreach and for more accurate information here. I particularly want to associate myself with the comments from the gentlewoman from South Dakota, Ms. Noem, when she says that we're all greatly concerned about conservation, and whatever it is we do, we want to encourage more conservation. So there's no one here, in my judgment, that's against that. On the contrary, we're very much for that. And with that in mind, I do want to just ask one question with regard to that, and that is this. If fewer people fish because the small streams are polluted, and if fewer people hunt because the wetlands have been drained, then would you expect that economic activities associated with hunting and fishing would be greatly diminished?
Absolutely. Outdoor recreation is an enormous driver of the economy, so clean water is critical to that.
Well, thank you. I think we, from time to time, need to remind ourselves what the purpose is here. But that doesn't in any way diminish the need for clarity and certainty and a process that's expeditious and encourages rather than discourages. And then just one last question. When are you projecting that the final rules will be determined and implemented?
So the interpretive rule is being implemented right now. It was the interpretation was good when it came out. In terms of the EPA proposed waters of the U.S. rule, I believe the comment period runs through October.
But then when would you expect implementation?
So implementation of the interpretive rule is going on right now. In terms of the proposed Clean Water Act rule, certainly towards the end of the year at the earliest, but I don't claim to be an expert on when that rule will be finalized.
Later this year or early next year sometime?
I believe that's correct.
All right. Thank you. Thank you, Mr. Chairman. I yield the balance.
Gentlemen, yield?
Sure.
I appreciate it. Mr. Bond, I just want to follow. Well, first of all, there was an exchange. I think it was our full committee ranking member about how fencing was now going to have to be permitted, but in your words, it was going to be fairly simple. I have some of the regulations, the diagrams, the complexities of it, and it's all different by fence type, and so I think we may disagree on the definition of the word simple.
I've got the fencing standard here, which I'm happy to give to staff as well.
Yeah, excellent. Well, I think we have it in hand here, and I think it's different by each state, and it speaks to I'm not sure when it comes to regulations there's anything that's really simple. We've had a lot of discussion about how you talked about this is normal farming practices, but then in the same breath you keep talking about additional exemptions. Well, if it's normal farming practices, I think it's counterintuitive to speak that you're going to be granting somehow in the future additional exemption. It's either normal farming practices or it's not. And the whole thing of opening this up on a regular basis within Nrcs, the Corps of Engineers, the EPA, allowing for revision, and I know you've alluded to that's going to increase flexibility, but I think it also equally opens it up to additional restrictions and more layers and layers of regulations in the future. And is that true?
NRCS goal, I think, remains to put conservation on the ground with producers, in partnership with producers. We think this will help us do that. And as we look,
if that was the case for of greater flexibility and promoting conservation, why is that not in the regulation? Why is not codified? Why is not specifically laid out to just take away the certainty that this will be a mechanism by which the Corps or the EPA or USDA would make farming almost impossible to do in the future?
So so EPA has already, the Clean Water Act already has upland conservation practices that are exempt from the Clean Water Act Section 404. What this does is add additional practices, clarifies through this interpretive rule that these 56 practices are exempt. So again, we think we've provided additional certainty.
Would you disagree, though, with the way it's written? It also opens it up that the EPA, the Corps of Engineers, or USDA that work together at least annually, at least once a year, it opens it up for more burdensome overregulation in the future.
I guess I disagree with the characterization because I think this is voluntary, doesn't require oversight by Nrcs, EPA, or the Corps, and makes no presumption that something isn't on the list is necessarily a violation.
Nothing that precludes any of those 56 to be taken away, correct?
No, I mean, it's possible that some of those 56 could be taken away in the future. Again, as I said earlier, I don't think we entered into this MOU lightly. We think that, there are opportunities to add additional practices there.
Well, I would, obviously would encourage you to enter into this with more due diligence and not lightly. And I apologize for violating my own rules. Whoops. Now recognize Mr. Rebel for 5 minutes.
Thank you, Mr. Chairman. I've got a whole list of questions, but actually I'm going to divert a little bit. And the question I really want to ask you is, what are the takeaways that you have as a result of this hearing, and what specific action items will that translate to when you leave here?
Well, I think, clearly we need to continue to focus on outreach, both within our own agency, with the other agencies, to make sure that this is applied consistency. And we'll continue to do outreach with the agricultural community to explain what this is.
So basically your takeaway is you have a communication problem?
Yeah, I think we can do a better job of communicating. I think we continue to believe that this creates opportunities for agriculture to put conservation on the ground.
Yeah, I would say with all due respect, Mr. Bonney, that it's more of a confusion problem than a communication problem. And you mentioned a couple times that the standards are currently voluntary. But in your view, doesn't including them as specific exemptions from the Clean Water Act convert those practices from voluntary to regulatory?
I don't believe that's the case. This is entirely voluntary. No producer has to use any of these exemptions.
Okay, in that case, which agency will be responsible for inspecting farms that claim conservation exemptions under this interpretive rule?
There's no requirement that there be any inspection that takes place.
I yield back, Mr. Chairman.
Gentleman yields back. Now recognize Dr. Schrader for 5 minutes.
Thank you, Mr. Chairman. All due respect, Mr. Bonney, this is a nightmare. It's probably one of the worst, egregious examples of government overreach I've ever seen in my lifetime. I've been involved in public service for way too many years, I guess. But the fact that NRCS is joined in this illicit grabbing of private property with EPA and the Corps just doesn't become an agency that I've had a lot of respect for in the past. Very disappointed. What was wrong with the 100-plus conservation practices you had on your list? Now there are only 56. What was wrong with those? What were you doing wrong and hurting our environment?
We weren't doing anything wrong.
So why are those 100 not all on this list?
Because there are two things that we looked at. One was it a practice that could be done in waters of the U.S.? There are a suite of practices that can't.
Do you think that the agency is the only determiner of what is an acceptable practice, that you know the exact correct fencing standards are going to protect that stream and there's no other fencing practice that could possibly help that stream?
No, we wouldn't presume that.
So
we
then
presume
why
that
are
our
you
practices do a
dictating
good
in these
job.
regulations specific guidelines for fencing? I'm on the Small Business Committee. We had a hearing. We had cattlemen come in doing the right thing. The stream's much better shape because he did some fencing, kept the cattle out. That fencing would not meet your standard. I mean, it seems to me it's crystal clear that you are trying to establish regulatory guidelines, standards by which a person farms, and you have no business doing so.
I don't believe we're trying to do that.
That's exactly what you do. There's only 56 ways. I see it. I'm reading it right here, man. There's only 56 ways you can do things.
It's voluntary.
And it is not voluntary. You keep saying that. That's wrong. Nothing voluntary about getting your butt sued because you didn't do one of these 56 practices. That's what's going to happen.
There's no presumption that not doing these 56 practices.
Get out of Washington, D.C. and get back on the ground. There are farmers and ranchers across this country that do not want to have this rule in any way, shape, or form. Did you or did you not have a public hearing and comment period before the interpretive rule?
No, we did not.
No, you did not. Any God-fearing environmentalists that have your head. Heck, they'd be living in trees around your house, for God's sakes, for not having that. How can you possibly defend what you're doing here? The Supreme Court case clearly says, United States, okay, waters of the U.S. must refer to relatively permanent, standing, or flowing bodies of water, not occasional, not intermittent, not ephemeral flows.
A mere hydrological connection is not sufficient.
I think you're
You have other waters. Why have you have a whole rule on other waters here? Why is it ditch?
It's not our rule. You're referring to the proposed Clean Water Act Waters of the U.S. rule. That's not our rule.
It's part of what's coming down the pipe beyond this egregious interpretive rule that you already have. How can you justify even relating to that when the Supreme Court case says specifically those waters should not be part of this discussion?
Well, again, the Waters of the U.S. rule is not USDA's rule. It's EPA and the Army Corps. What we've done here is create additional exemptions.
Do you agree that other waters, as an NRCS person, do you agree that other waters should be involved in this Clean Water Act interpretation going forward?
Well, I think other waters is part of the statute, as I understand it.
No, it isn't. That's the whole point. The Supreme Court has specifically said you're not supposed to be dealing with this. I hope you communicate that to our friends in EPA and our friends in the Corps.
One of the things we've encouraged is increase some of the exemptions under the current rule and into the proposed rule.
Mr. Chairman, all I've got to say is I think I've made my point clear that NRCS, unfortunately, is giving up its jurisdiction, is starting to prescribe what men and women can and can't do on their own property, way beyond what protects the health, the safety, and welfare of the navigable rivers or related to navigable rivers, waters of our great country. And it's a shame that people have the hubris in this community to think that they can dictate to farmers or ranchers that live, sweat, take care of the stewards of the land out there, specific practices. It should be about outcomes. It should be about outcomes, Mr. Bonney. You're missing the entire point entirely here. It's not about prescribing what men and women can't do or can do on their own private property. And I yield back.
I thank the gentleman. We're going to yield to the ranking member for a point of clarification.
Mr. Bonney, I'm trying to get this, and you're hearing the frustration, you're hearing it, and I'm hearing from you. I'm trying to clarify this, and I really think people are trying to get this right. Tell me this, if I frame it like this. Prior to the interpretive rule, if a farmer carried out a practice that's now listed in the rule, did that farmer have to get a 404 permit? And if they did, isn't the purpose of the interpretive rule now so they don't have to? Is that what you're saying?
In some cases, there will be practices where there would be a requirement for a 404 permit. In other cases,
how often did that happen?
I don't know.
Okay. But that's your point. So at the heart of this, if what you're saying, if this were interpreted the way you're seeing it and the way the interpretive rule is, and the questions that were valid, that there should have been input and all that aside, if this is working as you would like to see them work the best, this is what it should alleviate.
We hope we will reduce the permitting burden, and we expect we will.
Okay. Thank you. I yield back.
Thank you. Thank you, gentlemen. I'd like to seek unanimous consent to enter into the record of a number of things that we've made reference to today. Two things and one thing that has not made reference. One is the NRCS 382A, the fence or standard wire, the conservation practice job sheet, which will now be, with all the specifications, it will be subject to permitting. A copy of a letter entered into the record from essentially the Iowa agriculture community and from multiple stakeholders in the state of Iowa expressing their concerns regarding the Clean Water Act jurisdiction and NRCS technical standards. This is a letter dated June 18, 2014 to Secretary Vilsack. Request unanimous consent to enter that into the record. And finally, the document that the full committee ranking member made reference to, which is the USDA list of conservation practices, and this documented as has been amended with noting the ones that are now exempt, but leaves a significant number of practices that are identified by USDA and NRCS as conservation practices, which will now not be, which are not exempt. So without objection, those are so entered. We'll also have a copy, as the ranking member had asked me to share with you, Mr. Bonney. We'll make sure you get that before you leave. And I want to thank you for your testimony. I would encourage you, if all possible, to because we have not had a lot of communications and input on this beforehand. Staying around for the second panel, I think, would be very enlightening for USDA, and would certainly encourage you and hope that you will be able to do that. And with that, you're excused. I appreciate your being here.
Thank you for your time today.
Thank you. We'll now take some time to I want to welcome our second panel of witnesses to the table, and let's go ahead and get started that process. You want to make sure the secretary gets that copy or a copy of it. Finishing getting organized here, I'd like to welcome our second panel witnesses to the table. Mr. Don Perry, Senior Director of Regulatory Regulations with the American Farm Bureau Federation. Mr. Andy Fabian, producer, Fabian Brothers Farms, Indiana, Pennsylvania, is here on behalf of the National Cattlemen's Beef Association. Mr. Chip Bowling, First Vice President, National Corn Growers Association, with a large operation just south of the capital city in Newburgh, Maryland. And Mr. Scott Kovarovics. How'd I do? Excellent. It's a good day. I really do not like to mess up people's minds or names. There's only one thing you come in and out of this world with, and it's your name, and we all deserve to get it accurate. So thank you, sir. He's Executive Director of the Isaac Walton League of America out of Gaithersburg, Maryland. I want to thank the witnesses, and we will proceed here. Before you, as if you've seen, we have the light system. We try to adhere as much as possible. You don't need to stop cold turkey on red, but if you would finish whatever thought you're in the middle of, bring that to a proper conclusion so we can get around to hear all the testimony that each of you bring today and that we value so much, and have an opportunity for dialogue with the questions we have here. So, Mr. Parrish, with that, I'll recognize you for 5 minutes.
Thank you, Mr. Chairman. Thank you for members of the committee for holding this hearing today. I'm Don Parrish. I'm the Senior Director of Regulatory Affairs for the American Farm Bureau Federation. I've been dealing with the Clean Water Act for over 20 years. My wife says I talk about it in my sleep. I'm here to share my perspective on the Interpretive Rule. I would like to begin my testimony, though, with a little bit of an overview of the Clean Water Act regulatory proposal. This map that is in front of you corresponds with the current Code of Federal Regulations. Now, what you see on this map is 47 miles of permanent streams, 96 miles of intermittent streams. Those are the dotted blue lines. The gray lines are roads. The roads try to avoid those waters. What is interesting about this is that this is the current approximation of current jurisdiction. Go to the Code of Federal Regulations if you disagree. Look at it. It deserves your examination. What I want to express to you is that this is the limit of current jurisdiction. This is not all the waters that are in this watershed. This is 48 square miles, roughly 30,000 acres. So it's not that big a map. But note that any waters beyond this, and this map happens to be of an area in Kentucky, is regulated by the state of Kentucky. EPA, in the next slide, is changing 3 definitions: the term tributary, the term adjacent water, and the term other waters. This is what the jurisdictional reach looks like after those changes in definition. This map turns blue EPA will control virtually all land use on this 30,000 acres. Those little blue lines, this is what they look like. This may look like a stream, but this is a heavy rainfall running across a cornfield. And this land that's under this stormwater is going to be a water of the U.S. regardless of whether that water is there or not, because it contains a bed, bank, and ordinary high water mark. Let me turn my attention to the interpretive rule. The interpretive rule establishes binding and enforceable requirements for farmers. Currently, Nrcs technical standards, Nrcs technical assistance, and Nrcs cost share programs are, as Mr. Bonney says, they're voluntary. But the interpretive rule changes that. For 37 years, farmers could conduct normal agricultural practices on the land. But now, practices are only going to be exempt if you follow NRCS's conservation practices. And with regard to who's going to referee this issue going forward, and I quote, even where NRCS does not provide technical assistance, the agency plays an important role in responding to these issues that arise regarding project-specific conformance with conservation practice standards. And they're going to have citizen litigation looking over their shoulder to do it. The Corps of Engineers and EPA are also assuming a role that the law does not give them, neither the Farm Bill or the Clean Water Act, to adjust these standards. Farmers deserve better. They deserve direct, they deserve clear understanding, because the Clean Water Act is a strict liability statute, and that carries criminal and civil penalties. NRCS standards are complicated. They are far too complicated for strict liability under the Clean Water Act. I'll leave you with 3 takeaways. Agencies have confused you, they have confused the media, and they have confused farmers. This IR provides farmers with nothing they didn't already have. Number 2, in Iowa right now, 67% of all grass waterways and 50% of all the terraces are funded out of the farmer's pocket with no USDA or EPA or Corps of Engineers or NRCS funding. That conservation is going to be under now a cloud of suspicion. It's under a cloud that is probably going to result in that conservation being halted. And lastly, and this picture bears it out, normal farming exemptions are for activities. It does not exclude the land that's under this stormwater from being called a water of the U.S. in the future. And that type proposal, it invites litigation, and it's going to invite EPA right into the middle of how we farm into the future. There's only one solution. They have to withdraw it, and they have to make darn sure that farmers don't have to comply with NRCS standards to be compliant with the Clean Water Act normal farming practices. Thank you, Mr. Chairman.
Thank you, Mr. Parrish. Appreciate it. Mr. Faven, you're now recognized for 5 minutes.
Thank you. Good morning. My name is Andy Faben. I raise cattle and row crops in Indiana, Pennsylvania. I am testifying before you today as a member of the National Cattlemen's Beef Association and the Pennsylvania Cattlemen's Association. Thank you to the Chairman and Ranking Member for allowing me to testify today on the impacts of the Environmental Protection Agency and the U.S. Army Corps of Engineers Interpretive Rule on the normal farming and ranching exemption under Section 404 of the Clean Water Act. I am extremely concerned about the devastating impacts this interpretive rule could have on conservation practices being implemented on the ground, especially if you couple that with the increased liability from the expansion of the waters of the U.S. definition that is also currently taking place. As a farmer, my willingness to implement voluntary conservation practices has been greatly diminished, despite my desire to improve and protect the waters on my farm. I'm not alone in my thinking. which means that if this interpretive rule remains in place, farmers and ranchers across the country will slow their adoption of conservation practices. Therefore, NCBA is requesting the agencies withdraw the interpretive rule and begin a dialogue with farmers and ranchers in order to provide actual clarity that will encourage conservation implementation. As you can see on the screen, on my operation, we run 60 cows and have 3,500 acres of corn, soybeans, wheat, and rye. Also, we operate a soybean extrusion plant in which we process in excess of 1.3 million bushels of beans into high-protein soy meal and soy oil. I have ephemeral streams running through my pastures and fields, as well as ponds and ditches. Many of these features would become federal water under the proposal, with most not falling into any of the vague and unclear exclusions that EPA and the Corps have included in the proposed definition. EPA, the Corps, and Nrcs would have me to believe that despite the expanded definition, all the activities that take place on my farm are exempted. Unfortunately, not all ag activities are exempted under the Clean Water Act, and this interpretive rule would expand the number of farming activities that will need permits. The interpretive rule has narrowed the scope of normal farming and ranching exemption under Section 404 of the Clean Water Act. Since 1930s, Congress has encouraged conservation activities, making them integral or normal parts of farming operations long before passage of the Clean Water Act. We believe they have always been included under the exemption. Additionally, I am confused about the agency's intent. If the Corps and the EPA intended to clarify that the exemption covers conservation activities, why didn't they just say conservation activities are exempted as normal farming and ranching activities? They have made these voluntary standards mandatory because if you tell a farmer that he has to either comply with NRCS standards or face the permitting requirements or violations of the Clean Water Act and its fines of $37,500 per day, he hasn't been given any real choice at all. The only real choice is whether to do it the NRCS way or not at all. I'm afraid that most farmers and ranchers will pick the latter. NRCS was created to help farmers on a voluntary basis. Many producers, like myself, have a great relationship with our local NRCS agent. The interpretive rule states, the activity must also be implemented in conformance with NRCS technical standards. There is no way to get around that this requirement makes NRCS a Clean Water Act compliance agency. Farmers and ranchers are not going to allow NRCS fuel agents on their property knowing they are now an extended arm of the EPA and the Corps for Clean Water Act enforcement. I do not have an NRCS certified grazing plan for my cattle. I am concerned that the interpretive rule has unintentionally made grazing cattle without an approved grazing plan a violation of the Clean Water Act if they walk through a wetland on my pasture. I can't give you a better example of a normal farming and ranching activity than grazing cattle on pasture, but apparently now that exemption doesn't consider grazing normal. Now that the interpretive rule is in effect and my conservation practices are being scrutinized by the Corps and NRCS, my willingness to work with them has been significantly diminished. I'm worried local NRCS personnel are going to have to spend their entire time checking compliance of voluntary conservation activities instead of assisting farmers and ranchers in continuing to improve the waters around their properties. The model of voluntary conservation that has been the pinnacle of farmers and ranchers' protection of our natural resources is going to be upended. Not only should the EPA and the Corps withdraw their overreaching definitions of waters of the U.S., but they should also immediately withdraw the interpretive rule, because ultimately the only effect it will have is to decrease beneficial conservation activities. Thank you, and I would be happy to answer any questions members of the subcommittee have.
Thank you, Mr. Fabian. Now recognize Mr. Bowling for 5 minutes.
Thank you. Chairman Thompson, Ranking Member Walls, and members of the House Ag Subcommittee on Conservation, Forestry, and Energy, on behalf of National Corn Growers Association, I appreciate the opportunity to share with you our views on the EPA's interpretive rule regarding agriculture exemptions to the Clean Water Act. My name is Chip Bowling. I'm a third-generation farmer in Newburgh, Maryland, about 45 miles due south of here. I raise corn, soybeans, wheat, and grain sorghum on about 1,700 acres, and I currently serve as First Vice President of the National Corn Growers Association. The interpretive rule recently issued by the EPA and the Army Corps of Engineers specifies what farmers must do to qualify for Clean Water Act's normal farming exceptions from dredge and fill permitting. While the policy may have been intended to be relatively limited in effect and to be of assistance to farmers by making the exception process more efficient, in practice something very different will happen. Even if applied in the most practical and flexible manner possible, the fact remains that we are dealing with the Clean Water Act, a law that desperately needs clarification that can only be done by amendments to the statute by Congress. In the case of the interpretive rule, we see the potential that farmers engaged in normal farming activities will face far greater constraints than they had before to qualify those activities for the Clean Water Act exemptions. Producers will also face a far greater federal regulatory liabilities, either through the policy's implementation by the agencies in the field or from citizen enforcement suits against farmers. The interpretive rule establishes how the exemptions from Section 404 permitting will apply to certain agricultural practices carried out under Nrcs conservation practice standards. To date, some 56 practices have been identified for this purpose. NCGA is concerned that the rule will in effect require producers to follow Nrcs conservation practice standards, even though many of the covered activities are long-used, normal farming practices. The current list of covered practices includes many routine farming activities, such as brush management, weed control, fencing, and grass waterways. These practices have always been and will continue to be regularly carried out on farms for purposes unrelated to benefiting waters of the U.S., simply because building a fence, managing brush and weeds, and trimming trees are what are required to manage and operate a farm. The question is, will the consequence of the rule be either through its interpretation in the field or as a result of legal actions that farmers must closely follow the relevant NRCS standard any time they are engaged in one of these activities? If so, this is major cause for concern. Not only is this permit-like requirement for what should be an exempt activity, the everyday use of these standards is simply impractical. For example, the standard for brush management is 4 pages long and requires a farmer to develop a very specific plan that is ecologically sound and defensible. I'm not a big farmer. I am the entire compliance compartment of Bowling Farms. I find it hard to conceive how I could possibly have a written or recorded plan for each of the roughly 150 fields that I farm in my operation. If the activity is being carried out as part of an NRCS conservation program where federal funds are being utilized to help a farmer achieve a specific conservation purpose, meeting such a standard can be sensible and good policy. But NCGA believes that requiring farmers to meet such standards as part of an everyday farming operation is unreasonable and bad policy. In reviewing the covered practices, we find several that create this same kind of impossible compliance situation. Grass waterways are a good example. Most landowners and farmers had them on their farms. I have them on mine. And most were developed and installed without any assistance from NRCS. The NRCS standard in this instance is 3 pages long with very specific design criteria and engineering standards. It requires a detailed written plan and has limitations on how the waterway can be used. Portions of this standard are good practice and frankly common sense. However, if a farmer must now develop a plan for all of these and meet NRCS requirements or face possible litigation under the Clean Water Act, the expense in time and money will be enormous. The 2 examples that I've outlined are the type of concerns we believe to be serious and important enough to require this interpretive rule be withdrawn. In withdrawing the rule, it is imperative that it be made absolutely clear that this policy was meant to address only those circumstances where a practice was being adopted for conservation purposes to achieve a specific water quality goal. That notice of withdrawal must also specify such normal farming practices, when carrying out as a part of the ongoing operation, will qualify for Section 404 exception. Once again, we thank you for the opportunity to provide you this testimony and your decision to hold this hearing so that these important policy matters can be thoroughly reviewed and discussed. Corn growers will continue their efforts to conserve soil, water, and nutrient resources and protect water quality. We look forward to working with you and the administration and support your good work. Thank you.
Thank you, Mr. Bowling, for your testimony. Now it's my pleasure to Ask Mr. Kovarovics for his testimony for 5 minutes.
Yes, thank you very much, and great job on the name. It's a huge frustration for my kids, and I've been telling them, get used to it. So I appreciate Mr. Chairman Thompson and Ranking Member Walls and members of the subcommittee the opportunity to be here today to testify concerning the interpretive rule. I'm the executive director of the Isaac Walton League of America. We've got about 44,000 members across the country and 250 community-based chapters. These folks are working on the ground to conserve and restore natural resources, enjoy hunting, angling, recreational shooting sports, just about any type of outdoor activity you can imagine. And I'm here to share their perspective as well as the perspective of a broader cross-section of the community of Americans who enjoy hunting, angling, and outdoor recreation. And I believe it goes without saying that America's hunters, anglers, and farmers agree that healthy natural resources are essential to our traditions, our way of life, and our economy. And hunters and anglers know that habitat on private land is essential to the health of wildlife all across the country. Moreover, hunting overwhelmingly occurs on private land. Some 78% of the days spent afield take place on private lands. Because we share common goals, hunters and anglers are partnering with farmers nationwide. We're working together on restoration projects on the ground and advocating for farm bill programs and funding that directly support the conservation of natural resources on private lands. Ensuring the nation's streams, wetlands, and other waters are healthy is vitally important to the tens of millions of Americans who hunt and fish, for our communities, and for the outdoor recreation economy. Wetlands and streams provide vital habitat for fish, ducks, and other wildlife. For example, the prairie pothole wetlands of the northern plains in southern Canada support 50% of the North American duck population in an average year, and as much as 70% of that population when water and grass is abundant. The ducks that hatch and grow in these wetlands are harvested all across America every fall. Headwater and other small streams provide vital spawning habitat for trout, salmon, and other fish, and are essential to these fish throughout their life cycles. However, Supreme Court decisions in Swank and Rapanos and subsequent agency guidance, these vital resources are increasingly at risk today. According to the EPA, 60% of the streams in the lower 48 states, streams which flow to drinking water supplies of 117 million Americans, are at increased risk of pollution. Wetlands are not only at greater risk, the nation's losing natural wetlands at a growing rate. In the most current status and trends report from the U.S. Fish and Wildlife Service, the service concludes that wetland loss increased 140% between 2004 and 2009 when compared to the previous assessment period of 1998 to 2004. This is the first documented acceleration in wetland loss since the Clean Water Act was passed 40 years ago. Each year, 47 million Americans head into the field to hunt and fish. These aren't simply traditions or hobbies. They're fundamental components of our nation's economy. The money that sportsmen spend support everything from major manufacturing industries to small businesses and communities across this country. These expenditures directly and indirectly support more than 1.5 million jobs and ripple through the economy to the tune of $200 billion a year. Since 1977, the Clean Water Act has included an exemption from the Section 404 permit process for normal farming, silviculture, and rancher activities. As has been discussed today, the purpose and intent of the interpretive rule is to provide more clarity and certainty to farmers and ranchers and others about specific activities that are covered by the exemption for normal farming activities. And the Corps and EPA worked with USDA, as we've heard, to develop this rule and identify the specific conservation practices which meet this definition and are therefore exempt from the 404 process. I think it's also important to note, as Mr. Bonney did, that this rule is basically self-implementing. If the standards are followed, folks don't need to get advanced determination from the Nrcs about whether or not a water is a water of the United States, or to have pre-approval from the Corps or the EPA for the activity. In addition to issuing the interpretive rule, as folks know, the Corps and EPA have taken steps in the separately proposed Waters of the U.S. rule to more specifically define the waters that are and are not included in the regulatory definition. This is the first time that the agencies have specifically identified types of waters that are excluded from the regulatory definition. And the waters that are on that list that are excluded include prior converted cropland, groundwater, including groundwater drained through subsurface drainage systems, gullies, rills, and non-wetland swales. In issuing the interpretive rule in this section of the proposed Waters of the U.S. rule, the Corps and EPA have taken additional steps to provide clarity and certainty to farmers and ranchers nationwide. Over the past few years, stakeholders from across the spectrum, including sportsmen and agriculture groups, as well as Supreme Court justices, have called on the Corps and EPA to conduct a formal rulemaking to clarify the specific waters covered by the Clean Water Act. Issuance of the interpretive rule complements that larger process. And last week, the Corps and EPA announced they're extending the comment period. And the comment period on the separate rulemaking has now been extended to be 6 months long. In closing, the interpretive rule provides more clarity and specificity about a wide range of normal farming activities that are exempt from the Clean Water Act. Conserving and protecting streams and wetlands and other waters is vitally important to Americans who hunt, fish, and enjoy a wide array of outdoor recreation. And these activities are more than traditions or hobbies. They drive the outdoor recreation economy in America, which totals hundreds of billions of dollars and supports millions of jobs. Again, I appreciate the opportunity to testify today, and I'm happy to answer any questions. Thank you.
Thanks, sir. I'd like to thank all the witnesses for your written testimony that was all well prepared and your oral testimony. I'm going to take the liberty of starting with the first 5 minutes of questioning, and we'll just start with Mr. Parrish. The American Farm Bureau Federation and the other producers on this panel have been very clear about their objections to the interpretive rule and concerns with the administration's New Waters of the U.S. proposal. Why do you believe that your position is so different from that of the National Farmers Union, who also represents farmers and ranchers?
That's an interesting question. I've asked President Stallman that exact question, if he understood fully why the Farmers Union supported this. And his response was, and I think I concur with it, the Farmers Union made a very quick and snap decision. They had a statement out on this proposal within an hour of it being released. I don't know of any way they could have looked at 371 pages of clarity and determined that there was not problems for farmers and ranchers. I also don't think they looked at the issues of EPA regulating things that have flow in them only during rainfall events. Most people, and when Congress passed the Clean Water Act, they looked at the issue of fishable and swimmable. If you're asking people as to whether or not EPA can regulate either land or a feature that looks like land that may only contain water in it during a rainfall event, they would not believe that. At least that we don't think that's what Congress was looking at in 1972, because they used the term navigable. So we're not sure exactly why they come to their position, but we clearly understand that there's a huge difference in what's in black and white in this proposal and what sometimes the agencies say about it.
Sure. And I think my inclination was to trust Nrcs at first until I started to really read through this, and where my concerns quickly rose. Mr. Fabian, do you think that conservation will actually decline if this interpretive rule remains in place?
I would hope not, but I fear that it might. I guess we are more inclined to do the conservation practices because it's part of our value system as a producer. And we look to the NRCS for the guidance on the proper way to do that. And I think if we're going to start looking to them as a regulatory body, we'll be less likely to invite them onto the property or properties for that advice. So I think that it will have a negative impact on conservation.
Yeah, I think the NRCS should look to the experience of other regulatory agencies. You don't find a lot of businesses that freely encourage OSHA to show up.
We've never invited them.
Okay. Enough said then. Mr. Bowling, under the interpretive rule, what incentives will corn growers have to enroll in USDA voluntary conservation programs?
Well, the incentives will lessen. In my opinion, they don't become voluntary. As you noticed, I farm in Maryland. We also deal with a little thing called the Chesapeake Bay Mandate. And, after dealing with that, we are managing to do that. The only thing that I'm clear of and that is certain to me is I made it through yesterday with no violations. So almost all the practices that I do on my 27 farms, that almost 24 of those 27 are on a river or on a stream. The only thing that I know mine are voluntary. I do rely on NRCS for some guidance, but I very rarely take part in some of their programs. I do take part in the EQIP program and the Precision Ag programs to maximize my efficiency and to make sure that the equipment I'm using doesn't encroach where I'm not supposed to be. So I'll continue to do those things, and I think corn growers will continue to do those things around the country. But as far as, again, inviting NRCS onto our properties to take a look, that's going to be in jeopardy.
Thank you. Mr. Kverovic, thank you for your organization, what you do. I'm a lifetime hunter fisherman. I grew up in a small family sporting goods business. So in your testimony, you note that several groups called on the Corps and the EPA to engage in formal rulemaking on the issue of what waters are governed by the Clean Water Act. Is the decision by the EPA, the Corps, and NRCS to issue the interpretive rule without a comment period consistent with this process or a concern to your organization?
Well, I think, the interpretive rule is kind of like guidance, as I understand it. In some cases, guidance is issued without public comment. In other cases, it is. Sometimes it's after the fact. I think you heard from Mr. Bonney, today in terms of, learning from this overall process. There's a public process underway now, which provides that opportunity to participate and encourage everyone, to participate in that.
Well, I think this will be a very public process from this point forward, as the sense of the intensity I hear from the members of this panel. So thank you. I recognize the ranking member for 5 minutes.
Thank you, Chairman. Thank you all for your testimony. Very, very helpful. And I think maybe segueing from the Chairman, the teacher in me knows that this is an important piece of this. We're going to have to, and we know that the folks who feed and clothe this world, power the world, about 1.5% of this country. We heard that there's 47 million hunters. We need to keep in mind that leaves about 250 million Americans who we've got to educate about this process, who we've got to bring in this so that those snap judgments are made. And I encourage all of you, as you're doing, and what we encourage USDA is this is going to have to be a collaborative, transparent manner to get to our common goals, which is clean water, sustainable agriculture, and the ability for people to make a living as well as enjoy those legacy outdoor activities and fuel the economy through those. We don't have to make the false choices. We don't have to pick one over the other. We don't have to get into that, but we do have to make clear what those goals are. We do need to make clear as this rulemaking. And I think the biggest mistake here is it does not feel to me that there was enough of that input. It doesn't feel like we got enough of that out there. So when I see the picture, and I think Mr. Parrish is right, when I see that picture you put up there this morning, that looks like a picture that could have been taken this morning in Blue Earth County on Kevin Papp's farm as they're sending me pictures. That's exactly what it looks like, and I think that's a concern. And I also know that there is not that space between us. And Mr. Kverovic, you bring this up about how do you, and I'd ask each of you, first and foremost, is the NRCS the repository of all best practices on conservation? Are they? How would you respond to that?
I would say not. I would say, let me give you a practice that in California is against the law. Farmers in California cannot deep plow. And what I'm talking about deep plowing, I'm talking about a 6-foot deep subsoiler. Farmers in your neck of the woods can. Farmers in the Mississippi Delta can. That is the only agricultural practice that I know of that where you can pull a plow that EPA says that is not a normal farming practice. So I would argue that there is not anything consistent there, and that they're not the only repository because the university systems are always updating what farmers can do on the land. And I would also say that, whether it be the Extension Service or university systems, our systems evolve over time. And if you lock people in to certain practices, it's a real problem.
That's my point. Is there a fear of that happening, that instead of going to the extension of the University of Minnesota or the University of Iowa to get that information, now you're locked into that?
Here's the way I would explain it. If these 56 practices, and I heard Mr. Bonney say that the only way to be in compliance with the Clean Water Act is if you do these 56 practices, the way NRCS standards say you have to do them. And they're very prescriptive. They use a lot of shalls. If a farmer builds a fence that does not comply with NRCS's standards, the cloud then is that he's violated the Clean Water Act. The Clean Water Act is not flexible. It is very rigorous. And you know what? NRCS may not come and check his property, or the Corps of Engineers or EPA may not come, but citizen suits, citizen activists can come out and challenge that. And if the farmer or the neighbor doesn't like where he put that fence or exactly how he built it, they're going to go out there and then start measuring to make sure that the post that he built that fence with is 5 feet 7 inches apart. apart.
Could I ask Mr. Kavorovich, do you agree? I don't want to put you on the spot of speaking for an entire industry. I understand you're speaking for your members and you're bringing this up, but do you, and this is where we have to be collaborative, do you see the concern that Mr. Parrish and those landowners are speaking about on that, of where their concern is of how that could be interpreted?
Yes.
And how do we alleviate that? Because you've worked closely with landowners before, your organization has. Can't we do that again in this setting?
I think so, and I look at the projects that we're doing across the country, not only our organization, but so many in the sportsman community, working with landowners on the ground, putting conservation on the ground. If standards exist, we're going to be helping to meet those standards. I mean, you want these projects to be successful in their outcomes, right? And I've installed fence. I didn't know there was a standard for doing that necessarily. I do think it's important to understand here that this applies when these activities discharge material into a water of the United States. I mean, this isn't putting the fence through, the woods type thing. But yeah, I mean, when it comes to putting these standards in place, our organization, Trout Unlimited, others that are working with landowners on the ground, we want to make sure that we're doing it right and help to do that.
Yes, sir.
Just to clarify, do you know what EPA and the Corps are claiming is a discharge when you build a fence? Have you ever built a fence with a post hole digger?
I've built many miles of it.
And put the,
yes.
That's the discharge
that
they say they can regulate.
Now, that's very difficult for me to explain to my producers in any way possible. And I think you're not making that case. Again, I think we've got to stick together on this, those that care deeply about that, and we've got us all at the table. My time is up. We'll come back again, I think, maybe for a few more questions. But I'm of the belief that we can get this right, but there's 250 million people that aren't engaged in this the way you are. We've got to educate them.
Thank the gentleman. Now we recognize the gentleman from Ohio for 5 minutes.
Thank you, Mr. Chairman. I guess just to reiterate what you just built on, Mr. Walls, to Mr. Perry, to Mr. Parrish, we talk about, heard a lot from Mr. Bonney or the first panel. It's voluntary. It's voluntary. Well, it seems to me that this interpretive rule isn't very clarifying because it requires producers to be in compliance with the Nrcs standards, and if they're not in compliance, and they've had this blanket exemption agriculture has for normal farming operations, and if anything under normal, they're not in compliance. You concur with that, right, Mr. Chair?
I do. The follow-up questions to Mr. Bonney should have been, then, are they in violation of the Clean Water Act?
That was, I was hoping we were going to have time for a second round of questions that needed to be asked, and he probably would say, well, I don't think so, because that's the answer we got last week from the EPA. But so to follow up more on that, if a farmer deviates from the standards, they would not benefit from the exemption under the rule, correct?
That is correct.
So then the next question is, what agency would be the enforcement mechanism to make farmers comply or fine farmers, or if they're not, because the exemption is not going to work now?
Well, two things. Number one, USDA has agreed to in their MOA. And I read specifically, I quoted where they are going to be at least brought in as part of the arbiter. I disagree with Mr. Bonney on his characterization of that. Number two, the Clean Water Act is not self-policing. The Clean Water Act brings with it citizen suit violations. Yes. And believe me, any citizen activist group that disagrees with what you're doing or they take exception to the way you're doing this practice can bring you into court and force you to every dot and tittle as to whether or not you comply with NRCS standards.
And I think, too, everyone needs to remember what's creating this is the underlying proposed rule to extend the jurisdiction of the EPA on the waters of the United States, and that opens up the Clean Water Act to farmers, landowners, homeowners, everybody, to those citizens' lawsuits and permitting if you're not, don't fall into these specific exemptions, which I really think USDA and NRCS is being rolled here by the EPA. Mr. Chairman, I'm glad you had this hearing because this is really enlightening to everybody that we are putting at risk our conservation efforts because, as Mr. Fabian stated, probably not going to do things because you're fearful of the EPA is going to come in. And I guess another question for Mr. Parrish, since the underlying rule is the one that we know about, the interpreter is kind of the result of that, would the EPA have veto authority to come in and make determinations?
It sounds like they will every year. when they look at these practices. I am very concerned that these practices, if they're not followed to the letter, and again, I quoted to you that the number of practices that are done in Iowa just for people that build things like terraces or grass waterways. They do it because they want to. They do it to protect their land, to improve their land. This puts such a cloud over that I think it's going to really diminish the ability of farmers to do that on their own.
Okay, so that's clear. But I do want to have a follow-up issue that Mr. Bonney raised. I think he might have misstated. We talked about discharges under that because it was a court case on spray drift. Because I believe the court case, that's why my bill is so important, H.R. 935, because essentially the courts ruled that the sprayer is now a point source, and when you expand the jurisdiction of waters of the United States, it would require farmers, even though they're applying that pesticide under EPA label, they might have to get a 402 permit.
Okay, I really want to, this is an important distinction, and I want to clarify that. Spray drift is different than an actual direct discharge. Okay? So that's two different things. And in the picture that I showed of that cornfield, if the farmer drives his sprayer across that area when the water's not there running off during a rainfall event, that is a direct discharge. And therefore, he would need a Section 402 permit. Now, if the farmer stayed out of that area, didn't farm it anymore, and he normally does, and I would argue that that's an area that only has water in it when it's extensive rain. If he is completely out of that area and there is drift is treated differently than a direct discharge. And a direct discharge is regulated. Drift is illegal under all conditions. So it is illegal under FIFRA. Now, we can have a sidebar on that, but there is a distinction. Direct discharges are regulated, and this is going to put those direct discharges right into the middle of a farmer's field. EPA didn't develop because the reason this expands jurisdiction, EPA didn't develop a general permit for agricultural uses. This expands waters of the U.S. so much that now they're going to have to do a permit because they're going to regulate those kinds of areas I showed in that cornfield.
So in those instances, the farmers would have to get 402 permits for that instances, and I don't know delays and what the issue would be there.
That is correct.
Okay.
It's huge. It's huge.
Thank you, Mr. Chairman.
Thank you. We're now recognized for another questions from the ranking member.
I thank the chairman for, we've got great witnesses here, and this is an important topic we need to hear about. Again, I would make the case on this is that we should show great concern that our producers are showing this level of concern, because in working on these issues over the years, we've had great collaborative efforts, and there's that attempt to get there right. So this expression of frustration, concern, uncertainty is real. We're hearing it across the country. And also I'm hearing from our sportsmen who know we need to clean our rivers. We need to make sure we get this opportunity. With that being said, I just had a couple questions for me and for others listening who might not know this. Prior to the interpretive rule, how did you, the producers, know what practices qualified as normal activities? How did you know that?
Well, for me, I do have regular contact with my Soil Conservation Service and Nrcs and my FSA office. The most important ways that I learn is from other farmers that are older than me. My father, my grandfather before him taught me the right and wrong ways to do things. I didn't need to be regulated to be told that, and it's been passed down through generations. And I'd like to add that not only am I a farmer because that's my occupation, but I hunt because I enjoy it. Our farms on the river, I boat and I fish because it's time off, and I spend that with my family. So there isn't a person in this room that doesn't appreciate the normal practice of farming the way I do, and then to enjoy the pristine beauty where my family farm is and where I hope is there for generations to come. So there's nothing that I'm going to do that's going to jeopardize that in any way.
Mr. Bowling, do you think there's anything in this interpretive rule that makes our waters cleaner?
I don't
means that you're
specifically no. I mean, I've read through this rule. I just don't see it.
I would have to echo what Mr. Bowling said. My grandfather bought the farm that we're on sometime in the mid to late 1940s, and we have been implementing these conservation practices ever since then. So it's been just a rule that's how we farm. I really didn't look to the Nrcs for their regulations. Now, we certainly do go to them for some guidance, but it's a way of life for us. That's how we do things.
How could you describe, Mr. Fabian? Is it? I don't want to put words in your mouth. If it's frustrating or insulting, whatever, these things that your family has done for so long, now all of a sudden be told that, well, it's okay what you think. Someone else, though, will make that determination.
Yeah, it's a little suspicious that we have been given the responsibility for so many years and thought that we were doing it correctly, and now they're coming in and sort of implying that we're not.
And I think we're all open to new techniques. I've seen our folks work hand in hand with Nrcs, and
absolutely,
we've got great success stories. There's folks out there that are experts in this and know stream aquatics and things. So,
may I clarify
sure.
as to what the Clean Water Act says about normal farming?
Yeah.
EPA has two instances that they can recapture a normal farming practice, and that is if you impair the reach or the flow of water. Those are the only two things that would stop a farming practice from being considered normal. You would have to impair the reach or the flow of the water. So unless you're working directly in a stream, most farming practices don't impair the reach and flow of water.
And you believe, Mr. Parrish, this new one says, oh yeah, now that runoff you saw from the rain is now there.
Grazing, pruning a tree, I don't find any of those practices that would constitute a discharge. I don't find any way that it is impairing the reach or the flow of water. It adds confusion.
From a sportsman's perspective, Mr. Kvorvics, how do we reach this compromise? How do we get there? How do we understand? We understand watersheds are big. We understand the interconnectedness of things and all of that. How would you and how do groups like Isaac Walton League, how do we talk to these producers about, again, collaboratively reaching that common ground on this new interpretation?
Well, I think it's probably building on the dialogue and the work that's already going on out there. I mean, there's these partnerships broadly across the country. So many groups are working with individual farmers, private landowners, on many of these projects. And so, if this was an issue for a future project that's taking place in a water of the United States, then I think there would be, that opportunity. To work there. I mean, the bottom line for organizations like ours is we're partnering with private landowners on so many issues, and we want conservation to be successful, and we're working hard to achieve that outcome.
I'm just wondering if in the process now is not too poisoned or whatever you might say to go forward, do we need to come at this a different way? Because if there's suspicions up and if we're breaking down, then I agree with you on this. Long-held partnerships that are going to be strained by this that you're hearing from some of these producers, do we need to take a step back, approach this in a different way to get there? I don't know, any thoughts on that?
Well, I'm sorry. I'd like to add that groups like Isaac Walton League or Ducks Unlimited or whoever, in my opinion, they should reach out to us as we should reach out to them. Come out and visit my farm. I welcome that. I want you to see what I'm doing voluntarily. I want you to see how it's working for me on a positive way for fish, for migratory birds, for deer, turkey. It doesn't matter what it is on my farm. We plant food plots. We build migratory bird ponds. We have litigation area for other things to graze on.
And they do that, and I guess I see that the federal agencies could be the convener of those conversations. I'd like to see you two guys working together, which I know you do, to get these answers right. What concerns me is when they tell us neither one of you were invited ahead of time to do that. And I think if they could be the convener of the conversation, and you two can say, Mr. Fabian, I'm over my time, but if you'd answer, I'm interested if you had something to add.
Yeah, I did. I guess the NCBA has been questioned precisely 0 times from the USDA, so that's an easy answer. But I guess maybe a solution to your question is a new interpretive rule that says all conservation activities are part of normal farming. That might be one solution.
Fair enough.
I'd like to add, Mr. Thompson, you asked Mr. Bonney to stay here and listen to our testimony. and he's not here. And we're here talking to you now. You have two producers here that have taken their time to come in. We're not getting paid for this. We're doing it because it's the right thing to do. I firmly believe in what I'm doing is the right thing, and I would love for him to stay and heard what we had to say. I think he may have probably picked something up.
Mr. Bowling, I agree. That's why I made that request. And unfortunately, I think that just reflects the attitude of this entire issue that we're dealing with. So I do have these are quick questions that actually are better suited for Mr. Bonney, but just very quickly get your response to these three questions. Has our voluntary conservation programs failed? What's your opinions on that? Yes or no?
No.
Not at all. I think we're. Oh, go ahead.
Yeah.
I would say no. I would say they've given us the opportunity for these guys to achieve more than you would if you just give them a permit to farm.
Yeah. Well,
I would unequivocally say no.
Yeah, and Ms. Parrish, I think you used the term, we use it up north too. If it's not broken, don't fix it. And I spent all Monday morning on the Chesapeake Bay, quite a ways outside the 5th District of Pennsylvania, but we're in the Chesapeake Bay watershed with Colonel Jordan from the Corps of Engineers. And we've made remarkable progress, largely the result of the voluntary efforts of our agriculture community. Second question is, for those of you that have experience working with the professionals at Nrcs, and I appreciate what they do, they're our boots on the ground, but we're talking about significant increase in compliance work. Whether they want to pretend they're not going to be an enforcement agency, the compliance load, based on your experience and interactions with Nrcs, are they going to be able to handle this, this influx, dramatic increase in compliance work? And quite frankly, what happens if we don't get the paperwork processed? I guess we don't feed our citizens.
Well, yeah, those guys are swamped right now doing what they're doing. Most of them are local people that live in the area that work for these agencies. Some of them are friends of mine. Some of them have become friends of mine because of the relationship that I've had as a farmer going in there to make sure that I am in compliance. Every farm that I farm has a conservation plan. Every farm that I farm has a nutrient management plan. That work is done in those offices. They need more help now. I don't see how they can manage to do any more than they're doing. In my experience is that they get it done, but they rush through it just to get it done. So it doesn't hold me up from farming. If I don't have a nutrient management plan, if I don't have a conservation plan, I can't farm. I can't buy fertilizer if I don't have a nutrient management plan. So it's got to be done. We have to be on a regimented cycle of getting all these plans done. They do a great job at doing it right now, but I just don't see how the workload can be achieved by the people that they have now.
As a quick example, coming up on 2 weeks ago when I was doing some research for this testimony, I contacted our local Nrcs agent and asked him for a list of some of the activities that our operation has done, and I have yet to see that list. So a simple task like that, which should only take him 5 to 10 minutes, he has not been able to accomplish yet. So putting more projects on his plate, it's not going to get us anywhere.
And I just, I want to close my 5 minutes with just kind of revisiting, Mr. Rowling. I'm going to replow ground here and quote you from your testimony, because I think it brings up an aspect of this, a threat of this that has been mentioned, but I think it deserves to be elevated as much as we possibly can. And where you talked about citizen suits, and I've seen this on our national forests, how it really, citizen suits just interfere with the ability to properly manage land. Period. It has completely contrary outcome from what I think the citizen activist organizations claim that they have. We wind up with unhealthy forests, and we're going to wind up with I think, more unhealthy watersheds. And these, as you talked about with your neighbor, I guess, and I quote you, we've seen this very recently. One of my Maryland neighbors, a broiler farm. Fortunately, in this specific case, the courts ruled in favor of the farmer. And I think a lot of groups will say, well, you always have recourse. You can defend yourself in the judicial system. The question is, at what cost? And you've noted in your testimony, but at tremendous expense to the defendant, which nearly resulted in bankruptcy. I don't think this is the preferred outcome of this interpretive rule or the U.S. waters of the U.S., but it appears to me this is a realistic outcome that we can expect unless we can turn this back.
You're exactly right. I mean, I know the case you're talking about. I don't know the farmer himself, but I did donate to his cause because I would hope that if that were me, and thank God it hasn't been yet, that others would help me. The suit brought against him was basically he thought they had dumped chicken litter in an unauthorized spot, and it wasn't even chicken litter, it was municipal waste that was permitted to go on that farm. So, again, he had to defend himself on something that he was doing exactly by the book. He was doing nothing wrong, and it damn near bankrupted him. And I can tell you that the damage that it did to him and his family was way worse than the bankruptcy. He's now scared to make a move on anything. Again, I hope that doesn't happen to any of my other counterparts, but it's a very real scenario that happened. I see with this implementation here, I worry about that myself. I farm a lot around a lot of multi-million-dollar houses. People come out and watch what I do when I'm on the farm next to them. They pay attention to everything that I spray, how I plant, when I plow, when it rains, how soon I'm back in there. Every aspect of what I do is looked at. The public likes farmers. They don't particularly like the way we farm. They don't like us to do those things. I invite all those neighbors onto my farm. I explain to them what I'm spraying, when I'm spraying. I assure them that I would use nothing on my land that's going to hurt me, let alone them. So once I do that, it seems to go away, but the day is coming when I'm not going to be able to explain my situation. I'm going to have to prove it in a court of law, and I'm not looking forward to that.
Having spent time during this hearing looking through the fencing NRCS requirements, I got bad news. You can be sued by your neighbors if you have an ugly fence.
Yeah.
Because aesthetics are a part of the standards. Now, I don't know how you measure that, but that said, I want to thank the panel. Any closing comments? Thank you so much to everyone for your testimony. I think this has been very helpful as we continue in the process of dealing with this issue. Under the rules of the committee, the record of today's hearing will remain open for 10 calendar days to receive additional material and supplementary written responses from the witnesses to any questions posed by a member of the Subcommittee. The Conservation, Energy, and Forestry hearing is now adjourned.